Hi, everyone. Thank you so much for joining us this morning. So glad to have you with us. My name is Brian Darden. I'm the program director here at Focus and Fragile Kids. So hopefully we'll have some great information for you this morning. Heather Nadler with Nadler Biernath is going to be talking about guardianship, the pros and cons. And without any further ado, I'm going to send it over to her.
All right, good morning. Thank you very much for having me here today. Look forward to sharing this information. I always look forward to speaking to groups at Focus. Usually it's very interactive, but I think we're going to hold the questions till the end here at this point. So let's go ahead and get started. I got to find my slide. Are my slides up, Brian?
Yes, they are up now.
Okay, good. Everyone can see them but me. Here we go. All right, so obviously the topic for today is guardianship. This applies to kind of an older crowd, older kids, that is. And when I say older, I mean, kind of the brink of turning age 18 is really when we look at, is it going to be appropriate to get a guardianship in place or not? However, those parents of younger children who are here, welcome. Thank you for being here, and always good to gather more information so you can have these sort of things in mind as you proceed. So I wouldn't be a good lawyer if I didn't start out by telling you that the information you get here is not a substitution for meeting with an attorney and having the facts of your situation applied directly to the law. And also anything that is expressed here is just educational and general content. However, I still think you will find a lot of it useful. So my name is Heather Nadler. I am a certified elder law attorney. Our firm, Nadler Biernath, consists of myself and two other attorneys, many of whom you might have met or have spoken with, Laura Akins and also Kim Martin. I know Kim was here doing a presentation just like this during quarantine a few weeks ago. So we are devoted to practicing elder and special needs law. We're about 75% special needs law, 25% elder law. So obviously we do a lot of work in this arena and love working with focus families. So when it comes to guardianship, it is easy to get overwhelmed as you think about these issues with regard to your child. So what I want you to do today is kind of focus on the yellow and the red things when we talk about items. So things that are probable or things that are inevitable. Possible is where you get overwhelmed. Could this happen? Could this happen? Sure, a lot of things can happen, as we're kind of experiencing right now. It seems that anything could happen. But if you focus on those types of things, it's easy to get overwhelmed and not do anything. So I want you to stay more focused on things that are probable with regard to your child and things that are inevitable with regard to your child. One of those things that is inevitable is that they will turn age 18 and you're going to need to address this situation. So can't be an ostrich with its head in the sand. But even though someone's turning 18, it doesn't necessarily mean that guardianship is going to be the answer, the only answer. There are certain things that come into play deciding, hey, do we really need guardianship here? There are certain factors that play in. There is no black and white answer. There's no if blank, then you need a guardianship. So things that you need to think about with regard to your child, first of all, is intellect. Sometimes we do guardianships for people who have really low IQs. We have done guardianships for people who have really high IQs. So intellect even is not a bright line factor, but it of course comes into play. What does this person know? What can this person understand? What can this person meaningfully understand when it comes to making decisions about their well-being? So that's where intellect comes into play, only as one factor here. Secondly, we've got behaviors. How does your child act? How does your child respond in certain situations? And I've got another slide here in a minute where I'm going to give you some examples of behavior that can lean you one way or the other when it comes to making a decision. And opportunity. And the way I like to explain opportunity is how big is your child's world? Sometimes I will have clients come in and their child is 40 and they've never done a guardianship because that child lived with the parents. That child was involved in the same day program they had been involved in since they were 18 and interacting with the same people. And there was just a lot of trust and consistency involved in that person's life. And the parents say, gosh, we're embarrassed. Our child's 40 years old and we've never gotten guardianship. Now, I'm always a little surprised if someone has made it that far without needing a guardianship. It truly is a situation where they must be seeing the same doctors and either no specialist or the same specialist they've always seen, because at some point you need, you're going to come across somebody who's going to say, hey, how do I know I have the legal authority to be talking to you? But if the child's world is really small, there might not be an opportunity to be taken advantage of. A lot of times when a child is moving out into a supported living environment or going away to a post-secondary education program, that's where the child's world is getting bigger. And that's where it needs to be considered, okay, who is this child going to be interacting with? And do we need to put some more formality in place so that we can address things on their behalf? And not only formality, do we need to put some more protection in place? So, these three circles, as you can see in the slide, they overlap. And at certain overlapping points, yes, we're going to need to have more protection in place and have a guardianship. So you just need to be realistic about it. Some things, a diagnosis alone is not going to be enough to say, oh, my child has Down syndrome, we need a guardianship. Maybe you do, maybe you don't. My child has autism, same thing. So you need to figure out what actually happens. What is your child's life really like? How do they behave? Another big one is, what is their ability to communicate? As we will see later here in the presentation, what the standard that the court actually applies has the word communicate in it. Is your child able to make or communicate significant responsible decisions with regard to health and safety? So if your child is very high in the intellect category, but is nonverbal and can't communicate, if they need an advocate there on their behalf, then guardianship might be appropriate. So the one I wanted to come back to here was behaviors, because behaviors can play a big role in whether or not a person needs a guardianship. Even if they understand certain things, how are they behaving? How does that look to the outside world? How might they get into trouble and need some help and have a guardian there to step in and advocate for them? So the first thing is injurious behavior. Are they a danger to themselves? Are they a danger to others? If so, they might need this extra layer of protection and having a guardian in place. Do they have poor safety awareness? This kind of goes to the vulnerability issue. We can ask some clients, a question we always ask in kind of evaluating as we put together a guardianship petition is, could your child navigate a parking lot on their own? Or do they need to have someone around keeping them safe in a situation like that? And then another way that safety plays in, we will ask, has your child ever met a stranger? Does your child know stranger danger? Would they get in the car with someone to go help find the puppy? Would they open the door in the middle of the night to a stranger who says, hey, I need to come in and check your gas line, or whatever it might be? So are they easily manipulated by others as well? Back to that stranger danger. And this is where, like I said, the opportunity, how big is the child's world? If they are moving on to post-secondary education, if they are moving on to a supported living environment, even a new day program where they're going to be gone a significant amount of the day, are they going to be introduced to new people, and could they be manipulated by other people? That can certainly be a factor in deciding, what, we need an extra layer of protection here. We need a guardian. So is your child disruptive? And I don't mean tics. I mean walking into a restaurant and turning all the tables over, or causing physical harm to other people or property. That can be another indication where you want to have a guardian in place who can, if something like that happens, someone can then step in and advocate and help with the situation for your child. Personal space and property recognition, this kind of goes to, do they understand, do they get that you can't walk into a store and decide, hey, I want that candy bar, and put it in my pocket. You know, they might not be intending to steal, but at the end of the day, they were stealing, they were shoplifting. And that can be an issue where you're going to need a guardian in place to help straighten out a situation. Okay, so this is probably one of the most common discussions and questions that we get with regard to people is, could we do powers of attorney instead of guardianship? And that's where this next part of the presentation is going to focus. So the key to guardianship and the key to powers of attorney is, does this person have capacity? Does this person understand what they are doing? So with anybody, not just your children, but with you as parents, any other typical children you might have in your lives who are over the age of 18, that is the definition of capacity. When someone turns age 18, they are presumed to have capacity, and until it is proved otherwise. And that's the process you go through with the probate court and getting a guardianship in place. So with your child, I think a lot of times, and I think generally, with focus, you know, it starts with younger children, and so probably your child's disability had an age of onset which was before the age of 18. You know, if we have someone who becomes incapacitated after age 18, say for instance, if I were to get into a car accident and have a traumatic brain injury, then what had capacity at age 18, and maybe I signed a power of attorney, that power of attorney will continue beyond the onset of my disability. However, if I never had capacity before turning age 18, or even if I did but just never got my power of attorney in place, it's going to be too late potentially at that point to get it done. So if there is an opportunity, you as parents, other family members, like I said, typical children, you want to do some advanced planning. So powers of attorney, if your child had the ability to understand what it is that they are signing, then they could potentially avoid the need for guardianship and conservatorship if they didn't have some of those other issues, if they didn't have the behavior issues, they didn't have the vulnerability issues. Then perhaps if they can understand to sign a power of attorney, then yes, you can do that advanced planning, get that in place, and avoid the need to ever have a guardian appointed. Likewise, another place that we see guardianships or conservatorships, and I'll talk about the difference in those, getting put into place is when a child inherits money. You know, perhaps it might be that the parents passed away, and so now this child has money, yet they can't manage it. And so we say, oh, well, shoot, now we got to go to court and get a conservatorship to get that in place. Whereas if planning had been done on the front side of things, if there was some advanced planning, parents can leave that money in a trust, potentially a special needs trust for the child, and avoid the need for conservatorship that way. So these are things that families should be thinking about. Is there something that we can do, and possibly our child can do, in advance to eliminate the need for guardianship and conservatorship? So let's draw this distinction now between guardianship and conservatorship. When I first started practicing, Georgia had different terminology. They had guardian of the person and guardian of the property. And I actually really still like to use those terms in presentations like this and also with clients, because I think it's English. It's not legalese. You can get it. I get what it means to be a guardian of the person or a guardian of the property, and I can see that distinction. Well, guardian of the property is now known in the law as a conservator. So the guardian is the person who is responsible for health and safety decision making, and the conservator is the person who is responsible for financial decision making. And so when we talk about guardianship and conservatorship, we tend to just focus on guardianship, and that usually is the first step. But it's important to realize that there actually are two distinct roles that are to be served in that regard when you go before the probate court. So how might you be able to avoid guardianship or conservatorship? This is kind of the crux of that. So you could sign a power of attorney, And this is, again, not only your children, but this is you as parents as well. So a power of attorney allows an agent to act on your behalf when you are unavailable or incapacitated. So by saying that you are incapacitated, it means that you must have had capacity at the time that you signed this document. So that's back to that other slide where that might or might not be the case. So it allows an agent to act when you are unavailable notice. So for instance, I have a power of attorney. My husband is named as my agent. If he needed to go do something today while I'm giving this presentation, well, I'm unavailable and he could go ahead and do that for me. Likewise, if I became incapacitated, he could do that as well. And so the two powers of attorney that you would want to execute would be a power of attorney for financial decision making and a power of attorney for healthcare decision making. In Georgia, it's the durable financial power of attorney, and it's the durable advance directive for healthcare. So those are the documents that could be a substitute for getting guardianship and conservatorship in place if your child doesn't have some of the other intellect or behavior issues that might make it so that they actually couldn't sign a power of attorney. So, one more. In order to sign a power of attorney, someone must be over the age of 18. So this can't be done ahead of time when you are 18. That's when you have the legal capacity under the law to enter into a contract. And that's what a power of attorney is. I am contracting with my agent to carry out decisions on my behalf to act in my best interest. So I must have capacity, understand what I'm doing, and be over the age of at least 18. It must be an independent choice. So this is not, hello child, I need you to sign this document or else I'm going to go file for guardianship. It must be an independent choice. It also needs to be in writing, and it may need to be notarized. Typically, yes, you're going to want it notarized. And just to touch on this for a second here, in the day and age of coronavirus, the Georgia legislature just passed, excuse me, not the legislator, the governor, passed an emergency order late last Thursday saying that now we can remotely notarize estate planning documents. The process is pretty cumbersome. It involves everyone being on, a Zoom call or the equivalent together at the same time, the people signing, the notary, and the two witnesses. Then once everyone watches via the Zoom call, everything gets signed, then there has to be a series of emailing, scanning, faxing, however you can work it, to circulate that document all within one calendar day so that all the parties sign it. So depending on how long things continue, our office might implement that. We have not begun. I did do one notarization. It was just a notarization, though. We were doing actually a guardianship filing for the probate court, and we were able to carry that out remotely, which was convenient and does kind of keep the ball rolling a bit. The courts are still open. They're accepting filings via mail only, not in person. And then I don't know that they're allowing people to come in and take an oath. I know they're not conducting hearings at this point in time, but still, if your child is getting close to that 18 mark, it seems like, looking at Facebook, everybody I know is having a birthday. I never realized how many people have birthdays. Everyone's been posting their remote birthday celebrations. So if your child falls into that category, there is a notarization requirement as well for the guardianship petition. So that still can be carried out remotely if need be. Okay, so back to our discussion here on powers of attorney. So as we have said, a power of attorney, people will always say, can we avoid guardianship? And I will ask them, well, can your child sign a power of attorney? And we start in on this conversation. And they'll say, well, sure, she'll sign anything we put in front of her. Okay, that's not a good measure. That's not what I meant when I asked that question. Because if your child will sign anything that you put in front of her, will she sign anything that anyone else puts in front of her as well? So that can be a problem with, yes, can they physically sign a power of attorney? Sure, but is it accomplishing what you need to accomplish? So power of attorney could be a great alternative, but it's not necessarily going to be sufficient. So here are some of the limitations on that. The power of attorney does not remove any rights. So for instance, I used my husband as the example in my power of attorney. If he can go and carry out all these transactions for me, he can handle financial transactions, he can make medical decisions for me, but guess what? I can too. And if I say something, it's going to override whatever it is that he's trying to say. So the power of attorney doesn't remove any rights. And in your child's circumstance, you might need to remove some of those rights. You might need to remove the right for them to enter into contracts with other people because they could be taken advantage of. So guardianship does that. We're going to look at all the rights that are removed by guardianship. Guardianship is more cumbersome. It's more invasive, I think parents feel like, but at the same time, it's that way for a reason. It does it because we need to remove some rights, and a power of attorney doesn't do that. A power of attorney cannot void contracts. So my favorite not so hypothetical example on this point is if your child were to walk into the Apple store and were to sign up for a contract for a new phone and purchase that new phone and happen to have your credit card with them while they did that and said, well, yes, I do need that phone. And yes, I do need the 5-year contract that comes along with that. If that were to happen and your child came home and was so excited to show off the new iPhone, you would not be able to go back to Apple and say, oh gosh, my child didn't really understand what he was doing with this. I just need to return this and undo that contract. Apple could turn around and say, well, that power of attorney is a contract with you. Why can't your child enter into a contract with us? So you cannot go in and void that contract because your child had the right to enter into contracts and went in and chose to do that. So also with that, if you had guardianship, however, you could walk into Apple and say, I recognize the fact that my son entered into this contract with you, but here are the letters of guardianship, and you can see it states he clearly doesn't have the right to enter into contracts on his own, so I need to void that contract, and you would be able to do that. So I think that's a pretty good example of how this can play out in real life and a good demonstration of why that might be important. A power of attorney can be revoked. Your power of attorney might be working just fine up until the point where you try to go to the Apple store and void that contract, and your child is all too unhappy with you. Your child at any point in time, just like he could enter into that contract, he can void it as well. If I enter into that power of attorney with my husband and then decide, what, I don't want that to be my husband. My kids are old enough now. I'm going to change it over to my kid. Anyone has the right to do that under a power of attorney. So another issue you might run into, even if your child were to sign a power of attorney, could be that it might not be honored if the person or the institution that you are trying to use that power of attorney with has cause for concern to think that, well, yeah, that child signed that power of attorney, but did she really understand what she was signing? And the most common point where you might run into this would be with medical providers who are well acquainted with your child's condition and think, she didn't understand that power of attorney. I'm not comfortable acting on mom's advice here or mom's direction here. So we're going to want a guardian to get in place so that I, the doctor or whoever it is, know that I'm not going to get in trouble for, carrying out advice, especially if that advice is contrary to what your child is expressing they want to have done. Also, a power of attorney can be evidence of capacity. A lot of times parents will say, okay, well, my child's turning 18. Let's just give this a shot. Let's do the power of attorney, see how far we can get with it. If we run into trouble, can't we always go get guardianship? And the answer to that is yes. If you run into trouble with it, you could. But at the time that you fill out that guardianship application, one of the things that you will notice in the petition is there's a question, has this person ever signed a power of attorney? And if so, provide a copy and disclose it. So the judge would be within her rights to say, okay, well, what's different now, 6 months later than was going on, 6 months ago when you thought, oh yeah, my child can sign this. Why has your opinion changed? What's going on? So it can be evidence of capacity if your child has previously signed a power of attorney and might not, show you in the most favorable light to the court if the court thinks, well, they were just trying to avoid this guardianship. But say you didn't get a power of attorney in place, or you didn't ever file for guardianship, and then some sort of emergency situation happened. The state does have a plan for that, and we are happy that the state has a plan for that, although it's very stressful and expensive to implement. So emergency situations, first of all, are different. If any of us were lying on the side of a road following a car accident, the EMT is not going to show up and say, I wonder if they have a power of attorney. Well, what should I do here? So there is implied consent for those true emergency situations. Also, involuntary committal. If you had a child, we see this most often, obviously, with mental health issues. If someone has a diagnosis of bipolar disorder or schizoaffective disorder, you can still get someone involuntarily committed. However, that is still a process through the probate court. It is not even guardianship. A guardian cannot even do this. Involuntary committal is an entirely different process, but those do exist for true emergency situations. So even if you needed all of a sudden an adult guardianship or conservatorship, there's an emergency process. At the time you file, the hearing has to take place within 3 to 5 days. The emergency standard is you have to show an immediate risk of irreparable harm if a guardian or conservator is not immediately appointed. And that is a very, very difficult standard to meet. So it's not a situation where you think, well, we'll just kick the can down the road, and then if something happens, we can always get that emergency thing. Not necessarily. You don't want to bank on it. Also, if you file the emergency petition, you also have to file a permanent petition. Along with that, the filing fees, as we will discuss here, is about $700 for each petition. So it's also a lot more expensive way to go about it. So, my advice is, if you think, oh yeah, we are going to need a guardianship or conservatorship, I just don't want to do it. Just do it anyway, because you don't want to find yourself in this emergency situation. When a guardian is appointed, yes, we are removing rights from the ward. That's what the person under the guardianship is known as the ward. So the ward does have certain rights taken away, and this is definitely what bothers parents the most. I've already kind of beaten the dead horse about the right to enter into contracts. So yes, the right to enter into those contracts is taken away when the guardianship is put in place. And really, that's probably one of the most important rights that is taken away, that's going to provide the most protection for the child. Marriage, at the end of the day, is a contract. So the right to enter into marriage is taken away. And a lot of parents do not like that. It feels very draconian, taking away a civil right to enter into a marriage. It's important to realize any of these rights can be restored on a case-by-case basis. You can cherry pick and say, okay, well, yeah, we want to take away the right to enter into contracts, but we do want our child to be able to get married. However, having that right to marriage taken away can actually be very helpful. There are probably a lot of parents just in general who wish they could take away that right in the first place. But with regard to public benefits, if a child is drawing benefits on the record of a parent, which many of your children might be able to do if that child was determined to be disabled before age 22, then when you start drawing Social Security benefits, your child's going to be able to draw Social Security benefits on your record as well, so long as they remain unmarried. So hauling off and getting married could actually cause problems with regard to benefits. A lot of people don't think of that. But that is one good reason to have this right taken away if there's going to be a financial component messing up benefits. And like I said, you can always have that restored in the appropriate circumstance. Or I've got plenty of clients who just have a family ceremony, a church ceremony, synagogue, whatever, and just keep that, keep it not legally binding in the eyes of the state. So also the right that is taken away is the right to determine where to live. When the ward is under a guardianship, the guardian steps into the shoes of the ward and gets to make that decision where it is that they are going to live, what's appropriate. And then a lot of people, when they think about who they're going to name as guardian, as a successor guardian, who's going to help with all this when I'm not here anymore? This is an important one, that the guardian is just determining where the ward lives. It's not that if you name your sister to take over as guardian and your child has always been living with you, it doesn't mean that your child has to move in with your sister. Your sister just has to determine where's the appropriate place for the child to live. Also, the right to consent to treatment. This is probably one of the biggest reasons that parents do guardianship, is they say, okay, we need to be put firmly in control of making decisions for our child because she can't understand. She might act like she understands and say, oh yes, that sounds like a good idea, we should do that. But at the end of the day, you want the guardian to be the one who is fully understanding and making that decision. Now, it's very important, and I know that kind of the purpose of this seminar here today is to empower you, and so that you can do this filing on your own before the probate court. So very important to make it clear to the court that you will still involve your child in decision making, involve the life of your child to the extent that they are able to participate in those decisions. So always important to just let the court realize you're not trying to step in here and be a dictator, that you still are going to take into consideration the desires of your child and the opinions of your child with regard to all of these decisions, but in particular in deciding what kind of treatment your child is going to receive. And then this one doesn't come up too often, but if there is a trust that your child is the beneficiary of, that's a revocable trust, your child cannot revoke that once that gets the guardianship gets put into place. I'm sorry, I shouldn't say beneficiary if your child had actually created that trust on their own. Probably hasn't happened, but it's in the statute, so I mention it. Okay, so that's what's taken away. What isn't taken away? First of all, the right to refuse treatment. This always turns heads when I say, well, what do you mean? A child, this is really I always say child, it's really an adult at this point in time because we're talking about an adult guardianship and conservatorship, but it's your child. So if your child were to try and refuse treatment, again, most often we see this in the mental health arena, which I don't think is typically the clientele served by Focus, but the right to refuse treatment is always there. That's why that involuntary commitment proceeding is kept entirely separate. So if you had a ward who was refusing treatment like that, that's when you would have to go the involuntary route for that kind of treatment. The right to independent legal advice. So not all guardians are good ones. Not all guardians are doing the right thing. So we need to make sure that wards always have the ability to contest the guardianship and to hire an attorney to help them in that process. So that those next two rights kind of go closely hand in hand. The right to vote is not taken away automatically by a guardianship. So that's also a big question that I get a lot of times from parents, especially because I've had 2 or 3 clients over the years, these wards, who knew more about politics or elections or presidents or whatever. That was their thing. And they were very educated voters. So it was very exciting that they could vote finally when they turned age 18. The right to make a will is not taken away by the fact that someone has a guardian. You still have to pass the independent standard that any of us would have to pass in executing a will, which is saying that we understand the nature of our assets, we understand who our family is, we understand what would happen if we passed away without a will, and we want to change that. So Georgia law has provisions in place for anybody who's going to sign a last will and testament And so the ward would still have to pass those. But, again, thinking of someone who has a very high intellect, but is just very vulnerable to the influence of strangers, that person might understand fully well to sign a will. So that right is not just taken away. And then also the right to participate in decisions concerning them, if possible. Again, this just goes back kind of a practice tip, demonstrating to the court that, yes, we are going to be the ones in charge at the end of the day, but we are going to involve the ward to the extent possible in making all these decisions about their care. Okay, the common misconceptions about guardianship. This is not a magic bullet. In some ways, guardianship really is just a piece of paper. This is not going to make your child more compliant. This is not going to make your child want to go to the programs that you are trying to get them to participate in. This is not going to get them to take medicines that you've been wanting to take. So I never want to give the impression that this is a silver bullet. You're still going to have the realities of day-to-day life. This does just put you on a firmer footing, though, in dealing with outside folks and dealing with the day program and making the day program more comfortable with the fact that your child is pitching a fit and you're making them be there. Well, you're the guardian. You can do that to try and get them acclimated. Also, it does not affect access to public benefits. A lot of people get concerned about this because, as many of you probably know, when a child is under the age of 18, yes, you are their guardian, or their parent, and by virtue of being their parent of a child under the age of 18, you are their guardian, and therefore Social Security can look at your assets and your income, as can Medicaid, and you are potentially disqualifying your child for a whole bunch of benefits. And so people get concerned that, oh my gosh, if I become their guardian at the age of 18, aren't I still going to continue to disqualify them for benefits? And the answer is no. So that is a big misconception that I hear a lot. So even if your child is living with you, you are not going to disqualify them from public benefits by virtue of the fact that you are their guardian. So don't let that be an obstacle or a fear and a reason not to get the guardianship in place. One of the reasons that a lot of parents want to get this in place has to do with just in case the child ever gets in trouble with authorities. Over the age of 18, they're out, they're doing their own thing, even if you're with them. If they cause trouble when you're 18, you're an adult, and if you break the law, you break the law. Having that guardianship in place can be a mitigating factor. I think it goes a long way toward judges, even though there's nothing in the statute about it. It does go a long way toward judges recognizing that, you know what, this family is doing all that they can do to try and keep this situation reined in and keep everybody safe. So I think it goes a long way with judges. And then also, if your child is under the age of 18 and gets in trouble, then you as the parent get the call. If that child's over the age of 18, mom and dad don't get that call anymore. But if there's a guardian in place, then the guardian does get that call. And guardianships do get registered so that it would show up in the child's records or files that there was a guardian in place. The other thing is that guardianship is not a punishment or a failure. And some people love this phrase in life. I don't like it at all. It is what it is. But in this instance, I think it's kind of applicable to guardianship. If your child didn't have capacity at age 18 to do it, then they didn't have capacity to do it. And yes, you had to get the guardianship. It doesn't mean that there's been any sort of failure. It's not any sort of punishment against your child that they can't sign. So that can be a common misconception that is just upsetting to me on an emotional level with folks. So if you need it, you need it. We're glad it's there. Here's another big one. A lot of times I will hear, well, gosh, we don't want to be guardian because, yes, our child does have disruptive behaviors. And you know what? It's kind of a foregone conclusion that, yes, our child is going to get in trouble at some point, and we don't want to be held liable for that. If you think about it from a public policy perspective, when people in our society need help, we want others to step in and help them. So for that reason, guardians are not held liable for the acts of the ward simply by virtue of the fact that they're the guardian. Now, you might be liable for other reasons. And the best examples that I can always think of with this are with a car and a gun. If you know that your child is obsessed with driving and will do anything in the world to get out in the car, and you have not taken proper precautions to make sure that the car is not available, that the keys aren't lying on the kitchen table, for something like that, you might be held negligent by virtue of the access that you granted or didn't prevent to the ward. And but other than that, it's not that you are automatically liable for anything that they do. And you know what? If you left those keys on the kitchen table, or handed them over to your child who you knew darn good and well shouldn't be driving, you would be held liable for those acts potentially, whether you were the guardian or not. So really, that's kind of the best example I can think of to explain how this works and to reiterate that you are not liable for acts of the ward just because you're the guardian. Okay, so now we're finally to the meat of things here. And that is, here is what the court looks at and actually puts into play when it comes time for them to decide, okay, does this person need a guardian? So guardianship is needed when the proposed ward, again, that would be your child. At the time you file, it's a proposed ward, and then once the guardianship is granted, they become just the ward, because at that point, everything has been put through and has been granted. So guardianship is when the proposed ward cannot make or communicate significant responsible decisions with regard to their health and safety. Conservatorship, same language, can't make or communicate significant responsible decisions concerning their property. The parenthetical there is one that I have added. It says, and they have property. One of the things I want to go over with you is sometimes you need both guardian and conservator. Sometimes you don't. So with guardianship, the child turns age 18, then yes, we need someone to step in and make medical decisions. Okay, and yes, we would need someone to make financial decisions if the ward had any income, if the ward had any assets. And a lot of times that's not the case. There just aren't too many 18-year-olds who are sitting on a big pile of cash. Likewise, they might still be in school and not working. However, at age 18, a lot of times Social Security benefits will kick in, SSI, because as I mentioned, under the age of 18, you guys are disqualifying your children for all sorts of benefits because you have assets and you have income. But when they turn age 18, they are an adult. You no longer have a parental responsibility to support them, parental obligation of support. And so that terminates. So Social Security can't count your assets and income against them anymore. So when you go through to file for guardianship and conservatorship, there is a space on the application that asks about what's the income of the child and what are the assets of the child. And if they have income, you might say, oh, well, shoot, Social Security is going to start or just did start at age 18. So now we have income. Well, Social Security actually has its own program known as the representative payee, where you can become the rep payee of your child. And then through Social Security, you are required to report, if asked, about how the child's income is getting spent and used each month. So the probate court looks at that and says, oh, well, you know what? They're already under an obligation to report to Social Security, so we're not going to make them report to us as well. So if the only income is that Social Security income, that SSI that comes in and goes out each month, then the court says, all right, you don't have to have a conservatorship in place. So I've seen a lot of clients over the years who come in with guardianship and conservatorship because the petition that you fill out is set up for both. You get them both. And you kind of have to know to say, hey, guess what? We don't need that conservatorship. So that's, again, just another important practice tip. So you would need a guardian to manage the property and the income if they had any. Okay, so guardianship. How does this really work? What does this really look like? Who all is involved? These are our players. So the probate petition is a standard Georgia form. It is available on the Georgia Supreme Court website, they have standard probate forms where you can find it. But then within that form, people will get overwhelmed because they see all these terms thrown around and they're thinking, who in the heck are all these people? How do I fill out this form? So the proposed guardian or conservator, those are the people who, if this petition is successful, we want to have put in place. Here's who we want to have put in place as the guardian to manage healthcare decision making, and here's the person we want to have put in place as the conservator to manage financial decisions. The proposed ward, as I've already said, is your child, that is, or your loved one, whoever it is that you are looking to get guardianship over. That's the proposed ward. The petitioner is the person who is initiating this action before the probate court. And you actually need to have two petitioners. The first petitioner, let's say I'm petitioning for guardianship over my daughter. I'm the petitioner. Now I need a co-petitioner. That might be my husband, that might be my sister, that might be my dad, whomever. Next door neighbor, just needs to be another person who is aware of the condition of the proposed ward and is willing to sign on the dotted line and say, yes, I'll kind of be your support and backup here. That's the end of the involvement for that co-petitioner, unless they are also going to be appointed as guardian and conservator. Sometimes it's the two parents that are serving as the co-petitioners. But the petitioner doesn't have to even be the person who is going to be a proposed guardian or conservator. In my elder law practice, I will see this a lot of times if there is someone who is an elderly person who is in a nursing home and doesn't have any family, maybe they just got discharged from the hospital to that nursing home. And we've got to, and the nursing home says, hey, we need someone to be in control here, and there is no family. So the nursing home might be the petitioner there, two staff members of the nursing home. So they are petitioning, and then they are asking for the Department of Health and Human Services to be appointed. So I give you that example just to try and drive home the point that your petitioner doesn't have to be anyone who's going to have any ongoing involvement as a guardian or a conservator, but you do need two of them, two petitioners to get things going. Now, of course, there's an exception to every rule, and so one exception is you can have just one petitioner and then a doctor's affidavit. As if you were to look at the standard probate form, you will see in there that there's a doctor's affidavit. You only have to have that completed if you're using the doctor in lieu of a second petitioner. And it's fine to do that. The rare occasions where I do that are typically mental health cases, or if someone is very high functioning or might appear to be very high functioning and can kind of keep it together long enough to get through the medical examination. And I feel like we really need an learned, educated medical opinion to really bolster this before the court. Then that might be an instance where I would choose to use a medical doctor's affidavit on that. The only reason I really don't like to use them is because there are certain time limits that come into play. The examination has to take place within the amount of days before that evaluation is presented, is signed, is presented to the family, and then we've got to also to get it to the court within a certain number of days. So it's really just logistical reasons that I typically choose not to use the doctor's affidavit. It's just easier to get mom and dad or mom and grandma or whoever it is to get that going. So at the time that you file the petition, the court will take it in and we'll look at it and we'll decide if, okay, yeah, upon first impression at looking at this, it seems like there's something to this, let's move forward. And at that point, the court is going to appoint an attorney for the proposed ward. We are asking to have rights taken away, as we've already gone over here. And so the proposed ward is entitled to have legal representation in that process and to have someone advocating for them. Now, a lot of times those attorneys for the proposed ward step in and look at the situation and say, great, I'm glad that you're doing this. Clearly, this person needs a guardian. But these attorneys that are appointed for the proposed ward are court-appointed attorneys. It's essentially volunteer work that we do. I serve as either attorney for the proposed ward or guardian ad litem, we'll talk about in a minute. And you get $125 for doing it. And it's really just something that I think a lot of us feel a responsibility to do, to make sure that there's someone on the other side of things. You know, you might have a great attorney representing you, but who's looking out on the other side? And so it's just kind of some virtual, practically pro bono work that attorneys like myself will do. So guardian ad litem, this probably would not be involved in your filing. Guardian ad litem only comes into play if something unusual is going on. And usually it's on the financial side of things. So say, for instance, your child was sitting on $25,000 when they turned age 18 because they had just kind of collected birthday and holiday gifts, graduation, whatever, over the years. And so all of a sudden this child does turn 18 and yeah, they've got some money. Well, we might need to get that money out of their name and into a special needs trust so that they can qualify for SSI. So that would be kind of an unusual circumstance, and we would need to have the court's permission and blessing to do that. So whenever you make an outside of the box request to the court like that, they will appoint another attorney who serves as guardian ad litem, looks at the situation and says, yes, judge, I think this is a good idea and is appropriate. So probably will not apply in your circumstance, but it could. Then, of course, the court is involved. This includes not only the judge, but the clerk. So the vast majority of your interaction in this process will be with clerks. So when you file your initial petition, and then you're getting the medical examination scheduled, and you're trying to figure out the hearing date, and they need, more permission to run a background check, or any sorts of things. So you will have a lot of back and forth with the clerks on this, and probably will never lay eyes on the judge until you truly step into that courtroom. So just keeping in mind, the clerks have a very high caseload, and they are overworked and have a lot of expectations and a lot of timeliness deadlines that they have to comply with throughout this guardianship process. So be nice to the clerks. It'll go a long way. Then we have our independent medical examiner. So at the time you file the petition, like I said, the court looks at it and says, yeah, I think there's something to this. It looks like we might need a guardian, but they're not just going to take our word for it, nor are they going to take their own gut instinct about it. They want a medical opinion. So there will be a medical examiner who comes out and meets with the proposed ward. Typically that examination is done at your home, though it can be, sometimes you have to go to their office. A couple of the counties do it at the courthouse. I don't really understand that, but anyway, once you get the notice of the medical examination, it'll tell you when and where and who it is that is showing up, and it is your job as the as the petitioner to make sure that your child is made available for that examination. And they're pretty good about, not doing it during school hours, making it on the weekend or after hours. I mean, they're aware of, schooling and day programs, things like that. Okay, so here, I'm sorry this one's so small. Hopefully y'all can see it. Don't know how that happened. So when you initially file the petition, like I said, the court is going to look at it and make sure that there is sufficient evidence. Just like I said earlier, it's not enough for you to conclude that your child needs a guardian because they have Down syndrome. That's not enough to tell the court either. So the court really wants to see that you've got good evidence. If you file a petition that says, because within the petition there's a paragraph that essentially says this person needs a guardianship because, and then there's a blank space where you make your case. It is not enough to say because they have autism. So that doesn't mean they need a guardian. So you really need to flesh that out when you're presenting that to the court. Think about the standard. Are they able to make or communicate significant responsible decisions? And this can be a place to say, They're in special education, they have an IEP, if there's been an IQ test. I love to use grade equivalents. They read on the level of a second or third grader. Also, if you have concerns over the vulnerability of the child, they've been taken advantage of by kids at school, or by a stranger, or examples go really far in making a case. You just really need to look at that one little paragraph is really the heart of the petition, and you want to make sure that you've fleshed all that out, and that upon reading that, a judge or a clerk is going to look at that and go, yeah, this needs to move forward. So if it does move forward at that point, your child will be served by a process server or by the sheriff. Fulton and DeKalb use, for the most part, private process server to carry this out. But if you're in any of the other counties, this does mean police cars showing up in your driveway. So whatever that might look like to the neighbors, it could happen. More importantly, though, I don't really care what your neighbors think about it, but I do care if that's going to be extremely upsetting to your child. Plenty of wards that I've worked with over the years have a true phobia of anyone who is in a uniform, and it's going to freak them out and kind of taint this whole process. You can always ask for a private process server. You just need to bring that to the court's attention. And let them know, hey, we can't have a uniformed officer showing up to do this. But that's the next step. Once you file and the court says yes, that's when it gets served. In that packet that is served upon your child will be a copy of the petition. So your child is going to see what it is that you have said about them. With guardianship, I tend to describe it as, it's the opposite of an IEP. In an IEP, we are focused on, here's all the great improvements, here's everything that is happening, here's what we need in order to approve more, here are all the successes. Guardianship is pretty much the opposite of that, because we have to make our case. It has to be focused on limitations. So important for you to realize that your child is going to get a copy of that petition, and to the extent they are interested or able, they will read it and we'll see what it is that has been said about them. And so you need to prepare them for that. If that's going to be an issue, kind of explain what I just explained. You know what? You do so many great things, and you've come so far, but we still, need to get you just a little bit of help that you need, and that's why we had to do this. And this focuses on the negative. So your child will get a copy of that. Also in that packet that gets served upon them, there will be the identity of their court-appointed attorney, and also all the information about the medical evaluation. And you'll get a copy of that too, but just make sure that you pay attention to it. Don't think, oh, this is my copy, and throw it in a drawer, because it does have important information on it. Also, the petitioner, that's you, is responsible for paying the fees that are associated with getting this petition going. And the fees are pretty steep. I don't know if you have any familiarity with other filing fees in Georgia, but typically when you file a new case in a court in Georgia, it's about $250 to get the ball rolling on that. The filing fee for guardianships is usually more in the area of $550 to $650. $650. And the reason behind that, it's not just that the probate court is pocketing all this money. They've got to pay the process server. They've got to pay the court-appointed attorney. They've got to pay the evaluator. So, the actual filing fee is pretty consistent with what you would see in other courts. It's just we have a lot more players in the in the probate court. So you just need to be aware of that. That is filing fees, period, regardless of whether you've got an attorney assisting you or not. That's just the basic fees that go to the court. They do have a pauper's affidavit procedure where if you have limited income, limited resources, then you can apply to have that fee waived, and that's another separate application. And I believe that has to come straight from the court. I don't think that's available online, so you would need to contact your county probate court on that. And that's the other thing too. These are filed in the county where the proposed ward lives. So probably that's the county where you live, but that's the probate court that you are approaching. Now we've still got kind of a breakdown of some of the things that I've already mentioned, but there is some new information here. So interested person is the definition of who it says can apply. So you must have 2 petitioners or 1 petitioner and a doctor's affidavit. The court then appoints that attorney for the proposed ward. And then there's the independent evaluation. You know, a lot of times people will ask me, well, do we need to provide the neuropsych evaluation? Do we need to make that part of our petition? Do we need to provide, you know, information from the IEP, copies of documents, a letter from the doctor, anything? You really don't. All that's going to do is potentially drive up your filing fee, because a lot of times that's determined by the number of pages in your petition. And really, it's not admissible anyway, because the doctor isn't there verifying it, saying, yep, that's my report. So as long as that 1 paragraph is really good, you probably don't need any of those other things. Again, sometimes if it's a borderline case, then I will use some of those other reports and things if I feel like we really need to be bolstered, or if I feel like, you know what, I really want the medical examiner to see this, because the medical examiner will see it. It wouldn't be admissible in the hearing. We couldn't talk about it in the hearing, but you know, we're all human, and it kind of helps to have a little stuff rolling around in the back of the medical examiner's head if we feel like it's going to be a borderline case. So that independent evaluation that takes place, if you're familiar at all with a mini mental status exam, if you know, it's a lot of, you know, who's the president, draw the hands on the clock, repeat the following words in the same order, you know, those types of things. So what it doesn't test is the vulnerability issue of the child. So that's something you really need to point out in the petition. If that's the crux of why you feel like you need this, then really make sure that you have played that up in the petition, because that's not the kind of thing that's going to show up on a mini mental status exam. Now, it's not just that exam. The examiner typically will talk to the child and will ask, you know, broader questions about how they are, what doctors they receive, if they take any medication, you know, things that might make it clear that they're not really understanding everything. But again, if it's a borderline case, you want to make sure you're not relying just on that medical examination. So then this goes back to what I had said before about if your child does have a power of attorney in place. So the court is always going to make the determination as who is suitable. So again, let's suppose that you filed for guardianship, and then your ex says, no, I want to be the guardian. It's going to be up to the court to determine who is the most appropriate person to serve. So it's in the power of attorney that a Georgian typically signs. If you're using the standard Georgia form, it's going to say, if I ever need a guardian, here's who I want it to be. That's known as an advanced guardianship designation. So if your child has signed that power of attorney and understood at the time, which I think if you were standing in front of a court now asking for guardianship, you'd be trying to say, well, they didn't really understand at that point in time either. But that designation, who they choose, and same goes for under your wills. You know, you should have under your last will and testament who it is that you designate as a successor guardian. That person, at the end of the day, still is just a suggestion to the court. It's not binding on the court. However, the word I always use to describe them is kind of like a super creditor. You know, you got all your creditors down here, but you got a super creditor who has the mortgage folks, whoever has a secured interest. That person stands in as the probable best person unless it's proved otherwise. So in deciding who a guardian who's going to be appointed as a guardian, the court is going to look to any advanced designations, whether I made that under my power of attorney or your child made that under a power of attorney, or whether someone who was serving as my guardian already designated a successor. So say you had named me as the successor guardian for your child, and I was a great choice at that point in time, but since then, unfortunately, I've developed a terrible drug habit, and now I'm living on the streets. The court's not going to say, well, they chose Heather, that's who the guardian's going to be. No, that's why it's always just a suggestion, not binding on the court, but it is going to have to be shown that I am not a good choice for some reason. Okay, so after that independent evaluation gets conducted, the evaluator, who probably came out to your house, is going to file that report with the probate court. And the court may say, if it's sometimes a GAL, guardian ad litem, sorry, I should probably spell that out and not abbreviate that. The guardian ad litem might be appointed at that point. Say we did have a circumstance where, mom filed for guardianship, but dad is saying, her ex is saying, no, I want to be the guardian. That might be an instance where if there is no clear-cut answer, then the court might appoint a guardian ad litem there. I'd already mentioned we might have a guardian ad litem if we were asking to do something weird financially. But if there was a dispute, if the court has decided, yes, this person needs a guardian, but I just need some more information about who it should be, then they might appoint a guardian ad litem. That guardian ad litem then goes and talks to mom and dad and maybe the school and the day program and collects unbiased information to make a recommendation to the court as to who that might be. Now, I get this question a lot as far as I'm going to file, but I'm concerned that my ex-husband is going to make a stink about it. Well, there's two different kinds of making a stink. Is there making a stink by an ex who has 50-50 custody, is in communication with the school, is involved in extracurricular activities, who is very involved in the child's life? Or is this making a stink by someone who hasn't seen the child in 10 years and isn't paying child support and that whole scenario? Anybody can make a stink about anything. Anybody can object to anything. If you're filing for guardianship over an adult who has living parents, yes, you have to notify them. So even if my child has been with me for the last 15 years and we haven't heard anything from my ex, if he's out there, we've got to notify him. Now, rest assured, I'm going to explain in my petition, owes back child support, hasn't seen in, 7 years, whatever. But they still are a parent and have the right to be notified as long as those rights have not been terminated. So in any sort of situation like that, that's probably one of the most common questions that I get asked is, can my ex object to this? And anybody can object to anything. We can't stop that. But how successful is that really going to be? The standard the court always applies is the best interest of the ward. So who serves the best interest? The person they've been living with and who's been managing everything, or this person who's been long lost for the past 10 years? So with the guardianship, let me touch on one more question here because I get this asked a lot too, is can there be co-guardians? And the answer there is yes, in the right circumstance. If we've got long-term marriage, the child of both parents, and everybody has been involved and both parents are on the same page with regard to the care of the child and the living situation of the child, then yes, absolutely you can. One thing to realize though is that co-guardians is not an either-or situation. It's two halves of a whole. So it could be that if you've got co-guardians, then both parents have to be there for doctor's appointments. Both parents have to be there for school registration. Both signatures are going to be required for certain things because that's what guardianship is. Again, it's two halves of a whole. It's not an either or. So I always give that disclaimer to clients, and I know judges give that disclaimer to clients. Are you sure that you want to have co-guardians here? And typically the answer is still yes. And the way that it might play out in reality is both parents go to one appointment and say, you know what, we're co-guardians, and going forward, you know, you can communicate with one or the other of us. That's fine. And if the doctor's comfortable with that, that's fine too. But if you land in the emergency room one day and you walk in with your guardianship papers and it says guardian A and guardian B, then that emergency room, if they're making serious decisions or relying on the advice, they can say, where's the other half of your whole here? So just like to point that out to people. And again, even when I point that out, most parents say, nope, we want co-guardians. So that's perfectly fine. Now, exes sometimes will ask, can we be co-guardians? Actually have had that happen. In the best of circumstances, yes, you can. If you can demonstrate to the court that, you know what, we're totally on the same page with our kid, we just don't really care to be involved with each other on a personal level, then that is fine. So even that is possible in the right circumstances, although you're really going to have to work hard to make your case on that one. And where you will make your case is at a hearing. It is important for people to realize that becoming guardian is not just shuffling some paper. You do go to court, you do sit in a courtroom, you do get on the stand, raise your right hand, and you have to testify to the judge about why it is that you need to have this guardian and or conservator put into place. And then the court makes its determination as to, okay, yes, we need a guardian, we need a conservator, who's it going to be? Who is the most appropriate person? So in filing for guardianship, if you are a fan of crime shows, and you might be binge watching a lot of them these days, then you are familiar with the term burden of proof. And so we tend to think, you know, on CSI or Law and Order, than the murder cases, the burden of proof is beyond a reasonable doubt, which is the strongest burden of the proof. Then in some civil cases, you have preponderance of the evidence, which is kind of the other end of the spectrum. Somewhere in between there, you have clear and convincing evidence. That is the standard that you, as the petitioner, are required to meet in demonstrating to the court that, yes, we need a guardian, we need a conservator here. So clear and convincing evidence would be what you are providing when you get up on that stand. You need to testify as to what you personally know. And back to the question of the IEP or the doctor's reports, those are generally not going to be admissible at a hearing because it's hearsay as to you. You didn't prepare that report. You know, you can't testify as to the contents of it. So you're very much testifying about what you personally know. And guess what? No one personally knows your child better than you do. So, you know, clients might get a little nervous. Who wouldn't, about being put on a witness stand? I've had to do it. It is unnerving to be put on a stand like that. But at the end of the day, you're testifying about your kid. You know what I mean? Who knows your kid better than you? You're just getting up there, you're telling your story, you're telling your concerns about why it is that you need to have a guardianship put in place. At that hearing, if you had an attorney, then sure, yes, the attorney's going to ask you questions and, you know, get you going on that. But if you are there on your own, the hearing will probably start out with questions being asked either by the judge or by your child's attorney. Remember, your child has an attorney who's going to be there as well. And you know, it might just be an open-ended question, something along the lines of, hey, tell me about your child. Why are you here? And, you know, really, it's conversational. Once you get the ball rolling, you can do it. It's just getting up there and talking about your kid. Okay, so then So if there is a conservator appointed, then the conservator has to post a bond. You know, the court is putting you in charge of your child's money. Let's say your child has $50,000 and the court is going to put you in charge of that $50,000. Well, what if you run off with that $50,000? Well, the court wants to be sure that they can get your child back his or her $50,000 and then send Dog the Bounty Hunter, might be another show you're binge watching, Dog the Bounty Hunter after you, not really a bounty hunter, but to sue you to get that money back. And so it's really an insurance policy. With the guardianship or conservatorship, you also have to take an oath. You have to show up at the court, which you will be there for the hearing anyway. And typically this is done at the end of the hearing. If the petition is successful, you raise your right hand, you promise to abide by the rules that are put upon you as guardian and conservator, and you take your oath, and then the court issues those letters. So all of this, literally, you are doing for a piece of paper. You will be given one piece of paper that says, yes, Mary is the guardian now of Jacob. And that's the piece of paper that you take to the doctor, you take to the school, you take to the day program, anywhere that you are going where you are trying to act on behalf of your child. And so once you are appointed guardian and or conservator, of course, you have responsibilities. If you are conservator, and this is, like I said, we try to avoid conservatorship where we can. And if all that the child has is Social Security, then we can avoid it. But if you have a conservatorship, then you are required to report to the court. The court, again, I'm gonna stick with my $50,000 example, has put you in charge of this $50,000. Okay, so where is it? Prove to us, the court, that you are managing this in the best interest of your child and that this money is being used for your child and not for you. So each year you file an annual return saying, here's what I have, here's what came in over the course of the year, and here's what we spent over the course of the year. Here's the resulting balance, and here's the bank statement that supports that, that corroborates that. So that's what's required every year of a conservator. You would file a budget saying, okay, here are the typical ongoing expenses for my child. Here's the gym membership, and here's the therapy, and here's what we use each month for entertainment and dining out or whatever. So you file that budget each year with the court, and the court approves it. Then if something comes up that's off budget, as tends to happen in our lives, let's say your child were to wreck his car and you wanted to buy another one, and you wanted to use his money to do that, then you would have to petition to the court asking for permission to carry out that non-budget item. So conservatorship can be cumbersome. Also, you've got to be able to be bondable in order to do it, which depends upon your credit history, your work record, criminal history as well. So it might be that you are the most involved, but if you had a background or a history that didn't make you suitable, then you're not going to be able to be that conservator. So guardianship. Each guardian has the requirements a lot less cumbersome to serve as guardian, I think. These are the responsibilities of the guardian. The guardian must be available to the ward, must act in the best interest of the ward, must timely file all required personal status reports, a PSR. At the time you are sworn in and become guardian, you will be given this form by the court, which is the personal status report. It is a 1 to 2 page. Some counties are a little more thorough than others, but typically it is a very brief form that says, okay, where's the ward? Where are you, guardian? Because again, sure, the court needs to keep track of the ward, but they need to keep track of the guardian too. What has changed since last year? Has the medical condition changed? Has their employment changed? Has schooling changed? Graduated from high school, left the school system, and now on to a day program. Very basic general information. In fact, I tend to tell my clients, I'm going to send this to you. We're going to send it to you in Word form. Fill it out, and then just save it on your computer, and then you can go in and update each year pretty easily. So when you have that personal status report, at the time you get appointed, your first one is due within 60 days. So within 60 days, you need to kind of establish that baseline for the court and file that. Thereafter, it's just every year. Every year you need to update the court. And typically courts will not remind you of this. So you need to make a note in your calendar, a recurring event every year as to the deadline of when it needs to be filed. You will hear from the court if you don't file it, and then typically you'll get, the nasty gram that says either, some courts are getting pretty strict about this. We've set this down for a hearing, either get a report filed by X date or show up on the other date and explain to us why you shouldn't be removed as guardian. So if you did happen to forget, you'll get, one opportunity probably to get that in place before you would be removed as guardian. But the court holds the cards here. If you're not doing a good job, they absolutely can remove the guardian and the conservator. So another responsibility of the guardian is to use the ward's resources for the ward's benefit. And you must inform the court if there are any conflicts of interest. This is pretty rare. It didn't even happen to me. It was my partner, Mark, who had this happen, where he had mother and daughter were in a car accident, and daughter was injured. And so in order to get the money out of the insurance company, daughter had to sue mom to get to mom's insurance money. So that was considered a conflict of interest. So mom stepped back as guardian for a time. Adult brother got put in there as the substitute. And then when the lawsuit and everything was all over, brother stepped back again and mom went back in. So those are going to be pretty rare instances, but if there is any sort of conflict of interest, then the guardian cannot continue to serve because it's going to be adverse to the ward. So I think that does it for all this. The additional information, gaprobate.gov does have a lot of the basic information on serving as guardian and serving as conservator. However, their forms portal has not been working well of late. So actually the forms, rather than trying to mess with that gaprobate.gov, I would say just go straight to the Supreme Court of Georgia website. I don't know that off the top of my head, but our good friend Google can turn that up for you, and just find the standard forms there. And you'd be looking for the standard for an adult guardianship. You might think, well, wait, where's the form? Because this is my child. My child's a child, not an adult. Actually, at age 18, they're an adult. So you will see there are forms on there for guardianship over a minor, and there are also guardianship over an adult. You want to make sure you're looking at the adult ones. Also, some local courts will have some additional forms, a lot of times like a consent to a criminal background check, something like that. They might have some additional forms that they want filled out. So also just check your local county probate court for those forms. And if it turns out that they don't have them listed on their website, you don't get them. If they need something throughout the process, like I said, you're going to have a lot of back and forth with the clerks on this, and they'll get you what you need. The probate courts are designed to be user friendly, so the clerks are better than most at holding hands and walking you through things. And then of course our website has a lot of information on it as well, videos, perhaps even this video one day will be on there. So I am going to open back up to Brian now and see what questions have come in.
Hey, yes, thank you, Heather. So let's see here. We have got one question right now. Are you able, let me push this through and see if you can see it. Otherwise, I'll just read it out to you.
Okay.
You have your screen pulled up?
I do, but I don't see any questions on it.
Okay, well, I'll just read it out to you. How hard is it to revoke guardianship down the road? My son has always been a few years delayed. At 18, I don't anticipate he will be ready to enter into contracts, make healthcare decisions, etc. But what if down the road we feel like he is ready?
Yeah, that's a great question. So the probate court actually has a procedure for that, a restoration procedure. So we've had rights taken away, now we can have rights restored. And it is a separate petition that is filed with the court. And at this point, it is up to your son to prove that he can now make and communicate significant responsible decisions with regard to his health and safety and with regard to his financial management. And so it's kind of just a reverse proceeding. You file a petition with the court, he would need to be able to articulate that. You, as his guardian, could support that and articulating that. I have done, it's a pretty, we did have one in our office lately. It wasn't me, it was Kim's, where we got to have a restoration. I've done one in the 20 years that I've been doing this, and it's always a happy occasion before the court. They just don't come along that often. The court loves it, we love it, and so it absolutely can be done. And like I said too, certain rights can be restored. We can cherry pick and ask for certain things to be restored if you feel like it's something you need to ease into, and maybe not just rip that Band-Aid off from the get-go. But it's absolutely possible, and where it can be done, the courts love it.
Okay, awesome. So I haven't seen any more questions come in. So I'll just sort of stall a little bit in case anybody's typing, and say again, Heather, thank you so much for doing this. Is there anything you wanted to leave us with before we end this?
Yeah, let me add one thing that I never touched on as far as the timing for the filing. The guardianship cannot be awarded until the child has turned 18. However, you can file at 17 and a half. So that way you don't have a lag between the time the child turns 18 and the guardianship has been put into place and is fully up and running. So the way that works, once the child has turned 17 and a half, you can file, and then it typically takes about 8 to 12 weeks from the time that you file to get the guardianship in place. And so let's say you filed right at 17 and a half, everything might be done and completed still, even before your child is 18. So at that point in time, you could do all that. You could have the hearing, have everything. It's just that the court won't officially issue those letters until the child's 18th birthday, at which point they will put them in the mail and send them out. Or you might need to call and follow up in order to get them sent out. But that can be a really important step to go ahead and get that all in place so that there's not a lag between the time the child turns 18 and the time that you are actually sworn in as guardian. So that was, I don't know, I usually end up discussing that somewhere within the presentation, but today I didn't, so that just dawned on me that I hadn't touched on that.
Okay, well, thank you for touching on that, and thank you for all this morning. Really appreciate your time. Thank you to everybody listening. Appreciate y'all tuning in, and hope to have some more workshops for y'all coming up. We will see y'all later. Heather, thank you so much.
Oh, thank you so much for having me. Bye, everybody. Stay safe.